Tracking breaking news here at 8:30 on Up with Krem. The Supreme Court ruled to overturn Roe v. Wade.
Now, this decision overturns the longtime legal precedent guaranteeing the right of legal abortion here in the United States. The court's ruling in Dobbs versus Jackson Women's Health Organization was a determination of the constitutionality from a Mississippi law banning most abortions after the first 15 weeks of pregnancy.
The decision is likely to have major ramifications across the U.S. At least 13 have already passed so-called trigger laws, including Idaho. So with Roe v. Wade now overturned, access to abortion in Idaho will soon be practically non-existent. In 30 days, Idaho will have a complete abortion ban, with the exception for cases of rape, incest, or to protect the life of the mother. Now, this is due to what's called a trigger law. That was signed into law back in 2020 by Governor Brad Little. This law and others like it are automatically triggered when a certain criteria is met. And in this case, the criteria was for the Supreme Court to overturn Roe v. Wade. Idaho is one of 26 states with a trigger law in place.
Now, here in Washington, abortions will remain legal and protected. However, it is expected that Washington will see a huge influx of out-of-state patients seeking an abortion. Earlier this year, Governor Jay Inslee signed into law a state measure that prohibits legal action against people seeking an abortion and those who aid them. Abortion has been legal in Washington state since a 1970 referendum. A 1991 ballot measure, also approved by voters, declared a woman's right to choose physician-performed abortions prior to fetal viability and further expanded and protected access to abortion in the state, even if Roe v. Wade was overturned. So, of course, this morning we're continuing to track reactions coming in from people all over the state and even into Idaho as well. So Krem 2's Nicole Hernandez is joining us now in the newsroom with the latest on these reactions. Good morning, Nicole.
Good morning, Channing, Tim. So we're in a very unique spot here in eastern Washington, right on the border of two states that have very different views on abortion. Right now, we're seeing reactions from both sides of the aisle. Take a look at this tweet from Washington Senator Patty Murray. She says that today, Republicans dragged this country backwards by half a century. Republicans ripped away our rights and made this generation the first generation of American women with fewer rights than their mothers. Another tweet, this one from Kathy McMorris Rogers now. She says, quote, "This is one of the most momentous days in American history for the dignity and sanctity of every human life." On the other side of the aisle now, we have a statement from U.S. Senator Jim Risch. He says, quote, "Roe v. Wade was wrongly decided in 1973. Today, the U.S. Supreme Court took a major step to right that wrong." And Idaho Governor Brad Little says this, quote, "Abortion is not a right expressed in the U.S. Constitution. Idaho has been at the forefront of enacting new laws to protect preborn babies. The pro-life bill I signed into law in 2020 will go into effect later this summer." Now, Planned Parenthood of Greater Washington and North Idaho has been preparing for this landmark decision. As of now, 43% of all abortion visits to the Spokane Valley and Pullman clinics are Idaho residents. Planned Parenthood here is expecting those numbers to increase dramatically across the entire state. Planned Parenthood of Greater Washington and North Idaho says this in a statement, quote, "This dangerous and chilling decision will have devastating consequences for the patients we serve in Idaho and across the country, forcing people to travel hundreds, sometimes thousands of miles for care or remain pregnant." Now, we will continue tracking all of these local reactions throughout the day. In the newsroom, Nicole Hernandez, Krem 2 News.
All right, we are continuing to take a live look outside of the Supreme Court in Washington, D.C. right now, where you can see crowds are growing of protesters on the steps there in front of the Supreme Court. This has actually been going on for several hours now, even before the decision came down. There was a lot of speculation that this could happen today after it was announced that they were adding another decision day today before the weekend.
Now, this was a 6-3 decision. Justice Samuel Alito is the one who actually delivered the opinion for the court. And actually, the court's 3 liberal justices were the ones who dissented on this opinion. Of course, we'll be continuing to keep you updated on the latest on not only this protest, but as other protests continue to happen all across the country as well.
In the meantime, abortion rights were up for discussion in the Supreme Court this term because of one case, a challenge to restrictions in Mississippi.
So it's all about the Constitution of the United States and what rights are clearly defined, which are implied, and which are not protected.
Abortion rights were up for discussion in the Supreme Court this term because of one case, a challenge to restrictions in Mississippi. It's also about the Constitution of the United States and what rights are clearly defined, which are implied, and which are not protected. The Roe v. Wade decision back in 1973 came down to right to privacy, which usually rests on due process rights in the 14th Amendment of the Constitution, which protects the right to life, liberty, and property. But this latest decision says the right to an abortion was wrongly considered an implied constitutional right in Roe v. Wade. So let's verify. What other decisions rest on those implied rights? Our sources are Caroline Fredrickson, Georgetown law professor, and Robert Peck, constitutional law expert at the Center for Constitutional Litigation.
There's an interesting philosophical decision that's embodied in this opinion, and that is, to what extent are rights implied by the Constitution? This opinion asserts that abortion is not one of those implied rights.
There are other subsequent decisions dealing with equal marriage, gay marriage, and so forth that rest on the same foundation.
The idea of an implied right to privacy is the foundation of these other big decisions, like Obergefell versus Hodges, the case that legalized gay marriage, and Loving versus Virginia, the case that legalized interracial marriage, as well as Griswold versus Connecticut, which affords married couples the constitutional right to buy and use contraceptives, and Lawrence versus Texas, which made same-sex sexual activity legal in 2003. As for whether those cases are at risk, it's hard to say. Justice Samuel Alito argued the abortion issue is, quote, critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. But for nearly 50 years, abortion had been considered a procedure that fell under the implied rights umbrella.
It basically is an invitation to those who oppose those decisions to come back to the Supreme Court, frame your arguments the same way that this case, the opinion in this case, was framed, and then see if you can get the same result.
So while some legal analysts say those other rights are addressed in the majority opinion, others are concerned this decision is like a roadmap for overturning those rights as well. The Supreme Court decides what rights are guaranteed in the Constitution, explicit or implied. With your Verify, I'm Abby Larico.
So while some legal analysts say that Alito has addressed those other rights in his draft opinion, others are concerned this decision is like a roadmap for overturning those rights as well.
That's right. So the Supreme Court ultimately decides what rights are guaranteed in the Constitution, explicit or implied.